In the construction industry, a lot of the works and activities are controlled by contract law. So there is a contract that has to be established, and that contract would give rise to obligations, i.e., activities that parties need to perform. So it's important for us to understand what a contract means. That's the purpose of this video. I'll be explaining what is a contract. We'll be going through examples of contracts in the construction industry. I'll also explain the source of contract law when it comes to the construction industry, and then I'll provide a classification system for contracts. Let's first off start by looking at what is a contract. In simple terms, you can think of it as an agreement. It's an agreement that gives rise to obligations, and these obligations can be enforced by law. Now, the obligations are promises that are made, and these promises can be executed on the orders of a court when a dispute takes place. The oral or writing nature of a contract is very important for us to consider, because a lot of people have the misconception that for a contract to form, it needs to be in writing. That's not the case. You can have a contract that forms orally. The important point for us to note is that for any contract to exist, the parties in the contract have to be legally bound, and they have to have that intention of being legally bound. So if that intention is not present, then your contract is not formed. Some examples of contracts in the construction industry: a main construction contract, that's between the principal and, let's say, a contractor, so a construction organization. Subcontracts, you also have your employment contracts, and of course the insurances. When it comes to sources of contract law in construction, so we look at the statute, legislation that's specifically targeted towards construction. There are principles from the common law as well that will apply to contracts in construction. Most importantly, the court would look at the terms that are specified in the contract that has been established. So moving on to classification of contracts. The first type of classification is where we look at whether a contract is simple versus a deed. The main difference is that for a simple contract, you require consideration, whereas for a deed, there is no need for that consideration. What is consideration? Consideration is basically the price that a party pays in exchange for a promise. Most of the contracts that you find in construction are in writing, and they are simple. Now, a simple contract does not necessarily have to be in writing. A deed, however, has to be in writing. And when we look at the limitation period, there is a difference. So for a simple contract, limitation period is about 6 years in New South Wales, and for a deed, it's 12 years. Limitation period basically talks about the period of time that's available for a party to bring their claim before a court in case that a breach takes place in the contract. The second classification is based on whether the contract is unilateral or bilateral. A unilateral agreement is to the world, so it's a promise for one party to um, satisfy an obligation, and the way that this the contract would be accepted by another party is through performance of a certain act. So when it comes to unilateral agreements, we're thinking about most likely advertisements. So one party advertises for uh, for someone to do something, and that contract comes into existence and is satisfied when some party that's present somewhere performs that basic agreement that's been listed down in the advertisement. A bilateral agreement, however, is very specific, so it's between one party and another. It's not to the whole world. And no, like if the party is not part of the contract, there is no way that it can perform the obligation that is specified. So if I had an agreement between party A and party B, and then I had an external party, party C, that came in and performed the obligation that was listed in the contract, that's not possible in bilateral contracts. The contract specifically says that it's between party A and party B, and hence the promises have to be satisfied by these two parties. In a unilateral contract, however, that's different. So it's usually party A, and then on the other hand, you have the whole world that's able to satisfy the promise and whatever is mentioned in that advertisement. As soon as a performance of that act is made, this is where a contract is established. So that's the distinction between bilateral and unilateral. The third classification relates to the category, the specific category. So we've got, contracts that are specific to employment between the employer and employee. We've got, insurance contracts, and then we have construction contracts, which we talked about, between the principal, say, and a contractor, or, subcontract, so the subcontractors. This is a very good reference for you guys to check out as well.